So think about this a second. Where does your data actually live? I mean, really, we put so much stuff in the cloud now, don't we? Your company's sensitive emails, critical operational data, maybe even personal things. And well, for a lot of organizations, especially here in Europe, that somewhere is often tied to services from these huge U.S. tech companies. Today, we're going to dive deep into something really critical here. The U.S. Cloud Act, it's a U.S. law about how their authorities can get hold of data held by U.S. companies. And honestly, right now, it's causing quite a bit of concern that seems, amplified by the current political situation over in the United States. So we've gathered a whole stack of material articles, research papers, expert analysis to sort of unpack this for you. Our goal, cut through the noise, understand what the Cloud Act really is, how it kind of clashes with European privacy rules, and crucially, why the risks of using U.S. cloud providers might feel, well, more pressing now than maybe they did before, especially if you're a non-U.S. organization listening.
That's exactly it. Our mission here is to pull out the key insights from all this material. We'll look at the risks, especially those the source suggests are heightened by recent developments in the U.S., and we'll explore some potential strategies, some recommendations, but only based on what we found in the sources we reviewed. Yeah, it's a heavy mix of law, tech, geopolitics.
We'll break it down, right? Find the interesting bits, make sense of it.
Exactly. Let's get into it.
Okay, so basics first. What is this U.S. Cloud Act? You mentioned it's a U.S. law.
Yeah, enacted back in 2018. And fundamentally, it amended a much older U.S. law, the Stored Communications Act from way back in 1986.
1986. Wow. Okay, so pre-internet as we know it, definitely pre-cloud.
Absolutely. The world was different. So the Cloud Act's core power, the main thing it does is it allows U.S. federal law enforcement, think FBI, agencies like that, to compel U.S.-based tech companies.
Yeah.
Compel them using things like warrants or subpoenas to provide request data.
Right. And the reason this came about was because the old law made it super hard to get data stored outside the U.S., even if a U.S. company held it.
Precise. That was the problem they were trying to solve.
Okay, and here's the kicker. The part that really changed things with the Cloud Act is this power works wherever the data is stored.
That's the big one. It doesn't matter if the servers are physically in Virginia or, Frankfurt. If it's a U.S.-based company holding the data, U.S. law enforcement can demand it under this act.
That's the whole extraterritorial thing we hear about. It reaches beyond U.S. borders.
Exactly. The sources explain this really stemmed from law enforcement frustration. Think about a case like, say, Microsoft storing data in Ireland. Getting that data involved using these old international
MLR, Mutual Legal Assistance.
Yeah, those. And the process was just incredibly slow, involving government requests. The Cloud Act was basically designed as a shortcut, a direct line to the data held by U.S. companies located outside.
Okay, so direct access for U.S. authorities, regardless of server location. That immediately sounds like it could clash with European privacy. Where's the main friction point there?
It bumps right up against the EU's GDPR, the General Data Protection Regulation. Specifically, Article 48 of the GDPR is really key here.
Article 48, right.
That article essentially says that organizations in the EU shouldn't hand over data because a foreign court or authority demands it, like with a Cloud Act warrant, unless there's a proper international agreement, treaty, between the EU or the member state and the country making the demand, so the U.S.
So GDPR is basically saying, whoa, hold on. You need a formal agreement, not just a foreign warrant, to move data like that.
That's the gist, yeah. Now, the Cloud Act does have a mechanism for the U.S. to make bilateral deals to other countries. The sources mention agreements with UK and Australia, for example.
Okay, so some deals exist.
But the crucial point is there isn't yet a comprehensive EU-wide agreement specifically under the Cloud Act framework that squares the circle for all EU member states and satisfies that GDPR Article 48 requirement cross-border.
Ah, I see. There are talks happening, right, between the EU and U.S. on electronic evidence.
Yes, those discussions are ongoing. But as of now, according to the material, there's no finished agreement that fully resolves this specific Cloud Act versus GDPR conflict for everyone.
So you've got this gap. U.S. law compels disclosure globally. EU law restricts disclosure based only on foreign orders without a specific treaty. That's the fundamental tension.
It really is. And that tension is why using U.S.-based cloud providers, even if they tell you your data stays on EU servers, still involves this legal complexity for European organizations.
Okay, so that legal tension exists. But now let's get into why our sources suggest this feels, well, more pointed, more urgent right now.
Right.
They link it to the current political climate in the U.S.
Yes. The analysis we looked at points to recent political developments in the U.S., particularly since the new administration came in, as amplifying these concerns. It's adding layers of worry about relying on U.S. cloud services, even those operating right here.
Okay, what specific fears are coming up in the source?
Well, one major area relates to the perceived stability and maybe the effective of U.S. privacy oversight body. There's an agency called the Privacy and Civil Liberties Oversight Board, CLO.
CLO, right. I've heard of it. They oversee intelligence activity.
Exactly. They're meant to be an independent check on government surveillance and data collection, relevant to things like the current EU-U.S. data privacy framework. Yeah. The sources express concern that changes or, let's say, pressures related to these oversight bodies might affect their independence or their practical to monitor things effectively. And if that oversight seems weaker, well, that erodes trust.
So less confidence in the watchdog means more worry about potential over.
That's the connection. Yes. Another fear highlighted is the potential for U.S. authorities to maybe seek access to data held by European organizations using what the sources call pretextual grounds.
Pretextual grounds, like using a small, maybe legitimate reason as an excuse to go fish on pirate.
That's the idea. Now, there are still legal hurdles for accessing sensitive data, absolutely. But the sources raise questions about how strongly those those hurdles would be defended either by U.S. authorities respecting limit or even by the cloud providers back. There's a perception that, the rule of law or the separation of powers under some strain.
Okay. A worry about the system's checks and balances maybe not holding up strongly.
Sort of, yes. That's the concern, boys. And then there's a third tier. The possibility that the U.S. government might leverage it, that it could impose new requirements, maybe even sanctions, on its own U.S.-based cloud providers with goals.
Leverage its position.
Yeah, how?
Like weaponizing Europe's reliance on these big providers.
That's the framing used sometimes, yes. It could mean things like perhaps demanding that certain data must be stored in the U.S., pulling it back under reg, or maybe restricting services for certain customers or even whole countries based on U.S. foreign policy and security. If you're heavily reliant on one provider, imagine that service suddenly being cut off or changed fundamentally. That's a huge business.
Wow, okay. And this all connects back to the data privacy framework, the DPF, which is what currently allows a lot of data transfer to the U.S.
It does connect. The DPF is based on an EU decision that U.S. law provides adequate protection, but under specific conditions safe. But the sources point out that the concerns we just discussed about oversight bodies like about the DPF relying on U.S. executive orders, which can potentially be changed more easily than law as well, all that makes the framework seem potentially more fragile for some servers. And in fact, there are already legal challenges against the DPF or court.
Okay, so we've got the legal clash, the market reality of relying on U.S. giants, and now these amplified worries tied to the current U.S. political context. Let's bring it down to brass tacks. Why does this really matter to you, the listener, if you're running an EU company or organization?
It matters because it translates into some very real, tangible risk. First and foremost, the direct risk that the U.S. government could access your sensitive data. Even if you've paid extra or configured settings to keep it on servers physically located in the EU.
And that could put you in breach of GDPR?
Potentially, yes. Depending on the data and the circumstances, you could find yourself caught between complying with a U.S. demand and complying with your GDPR obligation. That's a terrible spot.
Is it purely about legal access requests, though? Or are there other security worries?
The sources do mention broader concerns, too. Things that go beyond formal legal process, the potential for espionage. Now, the analysis we reviewed isn't necessarily saying U.S. suddenly conducting mass spying on average European business, but the underlying technical capability of this and the concerns about potential use or just the implications of that are definitely part of the conversation.
Right. And you mentioned business continuity, board. That seems huge.
It really is. The risk that cloud services you depend on daily could just become or restricted or change in a way that's suddenly unacceptable as legal action, sanction, maybe new exports.
Yeah, if your email or core system suddenly went dark.
Exactly. For critical functions, that potential disruption is a major operating risk that needs serious.
You mentioned an interesting example earlier, something about an upcoming email problem.
Ah, yes, that was in one of the sources. It's a relatable scenario they paint. Think about organizations, maybe even government departments, currently running their own email servers, maybe using Microsoft Outlook on-premise.
Okay, yeah, a lot of places still do that.
Well, there's often a push, maybe for cost or features, to migrate to cloud solutions like Microsoft 365. If an organization make that switch, suddenly all their email data is sitting on Microsoft Cloud structure. And according to the sources, that very act of migrating places that data much more clearly under the U.S. jurisdiction concerns we've discussed, it potentially makes it a more obvious target for Cloud Act requests simply because of where it now lives and who's ultimately controlling service.
So moving to the cloud, even for something basic like email, can heighten these specific risks.
It can, yeah. And the sources also stress that for governments moving to the cloud, the stakes are even higher. They're dealing with sensitive citizen data, national security issues, public trust. So properly classifying their data, knowing exactly what's strict, what's confidential, public, can be absolutely critical before deciding what safely go into a cloud environment. But that classification itself is off mass now for big.
Okay, the risks seem clear and perhaps more acute. So what can organizations actually do? Sources did say just switching off these big U.S. providers is really hard, right?
Extremely hard, yes. The scale, the range of services offered by the hyperscalers like AWS, Azure, Cloud, they dominate the market for a reason. We're talking something like 70% buying market share in Europe versus maybe 2% each for the biggest European player, like Telecom.
70%, wow, that's dominance. And they offer that one-stop shop experience that's hard to replicate.
Exactly. They offer this huge, all-encompassing suite of services. Many European providers offer excellent niche services, but not that same breadth. So migrating off, especially for large organizations, isn't a quick fix. It takes serious time, money, and effort.
So not easy. But the sources must offer some paths forward. Strategy.
They do, absolutely. It's not hopeless. The material suggests a kind of multi-layered approach combining technical measures, legal safeguards, and smart choice about provider. One direct approach mentioned is to actively prioritize European first provider. Companies headquartered here operating solely under law. The sources name examples like Exoscale, Elastic, OVH Cloud, or did.
Okay. Providers based entirely in the
Using them gives you much greater certainty that your data stays under EU governance. The potential trade-off, as we discussed, might be in the sheer scale or the breadth of available services compared to global giants.
So maybe not a perfect fit for every single need, but a strong option for sovereign. What else?
Another option is using the EU data residency features offered by the U.S. providers themselves, like Microsoft EU Data Boundary. This aims to keep your data physically within EU.
That sounds good, keeping it local.
It helps, definitely. It addresses the data localization aspect, and this is a big but the sources emphasize there's still what they call a residual
risk, meaning?
Meaning, because the company controlling the infrastructure is still U.S.-based, that data could potentially still be subject to a Cloud Act order, even if the servers are in Dublin or Amsterdam. The U.S. company still holds the keys to the kingdom, so.
Ah, right. Parent company's jurisdiction still matters.
Exactly. So organizations need to carefully assess if that residual risk is acceptable for the type of data storing. Physical location helps, but it doesn't fully negate the U.S. control issue highlighted by the Cloud Act.
Okay, what about technical fix? Can tech help mitigate this?
Hugely important, according to source. One of the most powerful things you can do, implement strong client-side encryption, where you, the customer, control the encryption.
Client-side encryption, meaning the data is encrypted before it even gets to the cloud provider server.
Precisely. And you hold the only key decrypted. So even if the provider receives a U.S. subpoena and is forced to hand over the encrypted data,
it's useless to them without the key you hold.
Exactly. It's just scrambled data. The sources mention providers like AWS offering options for customer-managed keys as an example of this capability. And of course, basic encryption, encrypt data when it's moving in transit and when it's stored at rest. That's just fundamental table.
Right, gotta add those basic. What else is in the toolkit?
Exploring sovereign cloud initiatives, another recommendation. Things like Gaia X or the Sovereign Cloud Stack, SCS. These are European efforts trying to build a different kind of cloud. One that's more decentralized, federated, built around EU values like transparency, interoperability, and data sovereignty. They aim to provide tools and standards to have more visibility.
Sort of building a European alternative.
In a way, yes, or at least standard for one. And related to standards, the sources advise seeking out EU certification. Look for providers who adhere to things like the CICE Code of Conduct or the EU Cloud Code of Conduct. And keep an eye on the upcoming EU Cybersecurity Scheme for Cloud Service EF. That's going to be a voluntary certification, but it'll likely become quite important. It will assess providers against different security levels, basic, substantial, high, maybe even a high plus.
And those higher levels might include requirements specifically about data sovereignty or resisting foreign actors.
That's the expectation, yeah. Especially for the high levels, they might mandate technical or organizational measures to protect and non-laws Cloud Act. Understanding those ECS level, really important when to provide.
Okay, so certifications offer some assurance. What about legal and contractual route?
Also vital. Ensure your contract explicitly require the provider to comply with law, particularly yours. The sources also stress the importance of pushing for clauses where the provider commit challenging foreign data act that aren't backed by a proper.
So making the provider promise to fight for your data, legally speaking.
Essentially, yes. Building that obligation into the contract. Some sources suggest demanding the defend your data type clauses should become standard practice.
Makes sense. But even with all that, things can still go wrong.
Absolutely. Which is why the sources are unanimous on. You need an exit route, a plan, maybe even a plan.
Plan B, meaning you need to know how you'd get out if you had.
Precise. Who would you switch? Identify alternative providers where you need them. Critically, ensure your data is actually portable. Can you realistically move? Look for compliance with things like WIPO code conduct, which aim to make switching easier. And crucially, your plan B must include having independent backup of your critical data stored completely outside that main cloud service. Don't put all your eggs or all your data backup in one provider's backup.
Right, separate backup. And what if the service just stopped working or becomes unusable due to these risks?
You need emergency plans for that too. How would you maintain critical functions, basic email, file access, your primary cloud that suddenly vanished or became toxic? Thinking through those disaster scenarios.
Okay, that's practical. Anything else?
Just the ongoing need to monitor and adapt whole land hack laws, policy, U.S. and stay informed, regularly review your choice, and importantly, make sure different parts own or IT teams might focus on efficiency and cost, while your legal or policy folks worried about sovereign client deal. And that foundational step, properly classifying data, knowing what's sensitive and what not, requires input.
Okay, wow, that's a comprehensive address. So pulling this all together, it really feels like the core message from the sources is about this balance. You've got the amazing power and convenience of these global cloud platforms, mostly US-based, right? But you have to weigh that against the need to keep control, to maintain sovereignty over your data, especially in this, let's say, shifting geopolitical climate.
That's exactly the dilemma. And a really strong takeaway that came through in the analysis we read is that you can't just, quote, regulate yourself out of problems. The EU is a leader in regulation, no doubt. These are major frameworks. But the sources suggest that regulation alone, or hoping foreign providers will always successfully push back against their own government demands, might not be enough in the long run, particularly with the heightened uncertainty being cut out.
So regulation is necessary, but not.
That seems to be the view. Developing genuine European alternatives and capabilities and actively diversifying who you rely on those are seen as essential complement to the legal framework. Yeah. And the sources really emphasize shared response, not just on the provider, it's on you, the customer, to understand these risks, take proactive steps to protect your data. You can't just outsource that responsibility entirely.
That definitely leaves us with something to think about. Final thought for you, our listeners. Given everything we've unpacked from these sources, the Cloud Act, the GDPR conflict, the amplified concerns linked to the current U.S. political landscape, how comfortable are you with that trade-off? The undeniable benefits of dominant global providers versus potentially losing full sovereign control over your most sensitive data? Is the assumption that you're maybe too big to fail, or that these giant companies will guard your data like livestock, as one source put it? Is that really a robust strategy for your organization's crown jewel? What we've heard today suggests that seriously considering and maybe building your own plan B for data sovereignty and business resilience might be more critical now than it's ever been. Well, we hope this deep dive has shed some light on the U.S. Cloud Act, the risks involved, and some concrete steps you might consider, all drawn from the material we examined.
Yeah, thanks for joining us as we navigated through this complex but really important topic.
We'll definitely keep digging into issues like this. Until next time.